Thank you, Scott. I hope everyone can hear me. I'm listening, or I'm joining from Xiamen in China, and I'm having some problems with the audio of the previous three speakers, so I hope that people can hear me. The three previous speakers have talked about the UN Convention as a codifying instrument. Alistair mentioned that it picked up on trends in the practice of states and in customary international law, that it picked up these trends, it compiled and ordered these trends into the form of a conventional rules. And I want to talk about one of those specific trends which the convention codified into a conventional rule, and that is the protection of watercourse ecosystems, or commonly referred to as well as taking an ecosystems approach to the protection of shared watercourses. This was not created. This idea was not created by the convention. It existed in practice before the convention, but the convention provided a quite emphatic endorsement of the principle. Article 20 talked about an obligation of states to protect and preserve watercourse ecosystems. The International Law Commission had described this obligation as a specific application of Article 5, the requirement for adequate protection of the watercourse. That, of course, suggests that equitable balancing is required in respect of that rule. It also talked of it as an essential basis for sustainable development, and said, importantly, that it had ample precedent in state practice, and I think we can demonstrate that that's quite true. Also, Article 6.1, which set down relevant factors for equitable and reasonable utilisation, lists a number of factors which are inherently ecological. And of course, parts 4 of the Convention on Protection, Preservation and Management, where Article 20 is located, also included related obligations on management of environmental pollution, alien and invasive species, the protection of the marine environment, and also on sustainable management and the regulation of flows, all factors which are relevant to protection of ecosystems. But of the three global instruments, the UN Convention, the UNECE Helsinki Convention, the preceding convention from 1992, which is now a global instrument, and the International Law Commission's 2008 draft articles on transboundary ecosystems, they all include an element, or a variety of, or a form of an ecosystems approach. The UNECE Convention, again, quite emphatic, talks about the need for conservation and restoration of ecosystems, requires states to promote an ecosystems approach, talks about the ecologically sound management and protection of rivers and lakes, international rivers and lakes. And of course, that convention gave rise, or other conventions adopted under its auspices or influenced by that convention, including the Danube Convention, Meuse and Scheldt agreements, the Rhine Convention, and even conventions that preceded from the European region, like the Elbe Convention, all include provisions which support protection of ecosystems. The draft articles, the ILC's draft articles, again, stresses the role of an aquifer in a related ecosystem. And Article 10, the equivalent of Article 20 under the UN Watercourses Convention, an obligation on states to protect and preserve dependent ecosystems dependent on aquifers. But there has been a trend, to go back to Alistair's point about the role of the Convention in compiling, picking up on, identifying, compiling and ordering these trends in the form of conventional rule. We see provision which promote the protection of international watercourse ecosystems going back to 1969. So a number of examples are provided there. I won't go through them in detail. We also see in declarative practice soft law instruments going back to 1977 at least, many instruments that support this trend. Notably, Chapter 18 of Agenda 21, remember, a soft law instrument signed up to by 180 states. It talks about preserving the hydrological, biological, and chemical functions of ecosystems. It talks about water as an integral part of the ecosystem, and promotes safeguarding the functioning of aquatic ecosystems. So again, emphatic support. We have judicial support for an ecosystems approach. We have implicit judicial support going back to the 1997 Gabčíkovo-Najimaros case. In the context of precaution, it talks about the need for vigilance and prevention, principles of vigilance and prevention because of the irreversible character of damage to international watercourses. Again, that to my mind strongly suggests ecological damage. And it similarly talks about limitations regarding the reparation of such damage. The pulp mills case from 2010 emphasized the customary duty regarding EIA. Well, EIA, transboundary EIA or EIA of projects on rivers is an absolutely key means of implementing an ecosystems approach, requiring a proactive study of the possible implications, possible impacts of a project. But much more pointedly, the recent Kishanganga arbitration, the interim award from 2013 and the final award place stress on an obligation to maintain environmental or ecological flows in a shared watercourse. And interestingly, in this instance, they relied on Article 31.3c of the Vienna Convention on the Law of Treaties. The Permanent Court of Arbitration followed a previous case, the Iron Rhine case, where essentially they used this interpretive device, if you like, from the Vienna Convention on the Law of Treaties to incorporate subsequently adopted obligations in respect of ecosystem protection into pre-existing agreements, into pre-existing watercourse agreements of immense significance, this idea of systemic interpretation or treaty evolution. Similarly, the San Juan River case, the relevance of Ramsar designation of a contested site was of key significance, and the statements are really, really supportive of and imply or infer the court's acceptance of an ecosystems approach, even with respect to territorial implications. They talked about the environmental inseparability of a wetland, which was part of the contested territory. Of key importance here also are non-water conventions. We don't simply have to rely upon the water conventions that we have. If we go back to the 68 African Convention on Nature, Article 5 promotes the protection of ecosystems. Various regional treaties on marine protection of the marine environment from land-based pollution. Of immense importance, the 1971 Ramsar Wetlands Convention. And of course the Convention on Biological Diversity. Under these conventions, which are older than our water conventions, have had more opportunity for the elaboration of detailed rules and guidance, they provide a great deal of detailed normative guidance on what an ecosystems approach would involve, and are hugely important for us on understanding. We don't have a definition of an ecosystems approach. The Convention on Biological Diversity defines an ecosystem in terms of functional unit, having biotic and abiotic elements. Again, the 92 UNECE Helsinki Convention defines transboundary impact in a way that's very relevant to ecosystems protection. That transboundary impact includes human health and safety, flora, fauna, soil, air, water, climate, landscape, or the interaction between these elements. The 1994 International Law Commission commentary on Article 20 talked about an ecosystem as an ecological unit with living and non-living elements, and talked about the interdependence of these elements. The only real definition we have of any use is a 1994 definition by Brunet and Toup, writing in the Yearbook of International Environmental Law. They talk about the whole system, species and physical environment, the interconnectedness between these elements, that it's a spatially broad concept, and that integrity of ecosystem function is essential. So how do we implement it? Well, we mentioned EIA. EIA is essential for this kind of proactive anticipation of problems. EIA coupled with a precautionary approach, but we're increasingly receiving technical guidance, really, really useful technical guidance, through a process of communication occurring often under conventional instruments. For example, under the Helsinki Convention, we have 93 guidelines on the ecosystem approach in water management. Of central importance here is under the Ramsar Convention, the Scientific and Technical Review Panel, which has produced its handbooks on the wise use of wetlands, and various of these handbooks are very, very helpful in helping us to understand in detail what's required in terms of ecological protection of water bodies. And of course, national legislation is increasing in terms of its sophistication, in terms of its ability to address ecosystems problems in terms of water bodies and the water environment. A recent study by Stefano Berchi that I went through identified around 8, maybe more, modes of national legislative implementation which would give effect to, or help to give effect to, an ecosystems approach. 2 key things I want to mention just before I finish in terms of the developing methodologies. And one is environmental flows. We're developing an understanding of what we mean by environmental flows through various types of guidance, soft law, the Brisbane Declaration 2007, guidance by the Scientific and Technical Review Panel of Ramsar, various guidance issued on Ramsar and the Convention on Biological Diversity, a number of other technical toolkits, the statements of the International Law Commission in relation to transboundary aquifers, and of course the case law, the 2013 Permanent Court of Arbitration, particularly the interim award in Kishkaganga arbitration, and the final award, and the San Juan River case. So we're really getting a handle on what we mean by environmental or ecological flows, absolutely fundamental to ecosystems protection. And of course the idea of ecosystem services and the related requirement for payment for ecosystem services, again, provides us with an analytical framework for the economic and social valuation of ecosystem services, which really, really helps us to move towards understanding the significance of functioning ecosystems for the parties to a dispute, to an agreement, to a regime of international water law. The 2005 Millennium Ecosystem Assessment gave us a language, gave us a typology, 4 types of ecosystem services: supporting, provisioning, regulating, and cultural. And again, a wealth of technical guidance, all of which we've really seen since the adoption of the convention. So I think the ecosystems approach is really developing normative sophistication. We have a very, very clear idea on what this means. It's terrifically important that this was included, and included emphatically, in the UN Convention. It would be a huge gap. Our thinking on international water law would have moved beyond the convention if this provision were not included there. I think it's massively important that it was there, and I think it's indicative of the way that international law in this area, in terms of natural resources and environment, continues to develop organically. That this concept has developed while the convention itself was waiting to take effect, and it can now take effect when this one particular, this is true of other elements in the convention, but as this requirement has developed real meaning for us, real technical and practical meaning for us. The convention is ripe to enter into force now. When we, on issues like ecosystems protection, we know what the well-meaning requirements set down in 1987, what they actually mean. Thank you.
Thank you. That was an interesting and informative presentation that highlighted a part of the convention that I think a lot of people overlook often. So thank you for that insight.